Welcome everyone. Thank you all for coming today on behalf of the National Lawyers Guild and the American Constitution Society. We're so happy to collaborate and be able to bring this seasoned veteran of human rights law and great advocate for justice and civil liberties. And so I'd like to introduce Professor Marjorie Cohn, who's a human rights lawyer, former president of the National Lawyers Guild, and member of the advisory board for the Assange Defense team. She is also professor emerita at the Thomas Jefferson School of Law. She has served as a legal and political commentator on BBC, CNN, MSNBC, NPR, and many other outlets. You may have seen her on some popular podcasts recently. She has authored Cowboy Republic, Six Ways the Bush Gang Has Defied the Law, as well as made numerous contributions as an editor and co-author of several legal and political books. She is also the Deputy Secretary General of the International Association of Democratic Lawyers, an organization in which she once served as a legal observer in Iran in 1978. For more information, you can follow Professor Cohn on her website and see some of her writings, as well as access her books at marjoriecohn.com. I'll provide that link in the chat here soon. And so we are proud to extend a warm North Carolina welcome to Professor Marjorie Cohn. And we thank you for your years of experience as a lawyer fighting for civil liberties and human rights. And so without further ado, we'll pass over the mic to Professor Cohn, and then after her remarks, we'll open the floor up for questions.
Thank you so much, Nicholas, and everyone who invited me and helped to set up this important program. I'm honored to be here with all of you, and I know that finals are coming up, so I thank you for being here. Julian Assange founded WikiLeaks during the Bush administration's so-called War on Terror, which was used as a pretext to start two illegal wars and establish a widespread program of torture and abuse and illegal surveillance. In October of 2011, Julian Assange told a Stop the War coalition rally in London's Trafalgar Square, "If wars can be started by lies, peace can be started by truth." In 2010 and 2011, WikiLeaks published classified information that Army intelligence analyst Chelsea Manning had provided to them. Manning was prosecuted, convicted, and sentenced to 25 years in prison for leaking the documents. And as he left office, Obama commuted her sentence to the 7 years she had already served. Now Julian Assange is being indicted for exposing US war crimes in 2010 and 2011. Let's look at what he exposed, what WikiLeaks exposed, because there are a lot of myths out there about what Julian Assange did, but he is really being indicted for his revelation of US war crimes. The files that WikiLeaks published included 90,000 reports about the war in Afghanistan, including the Afghan war logs, which documented a greater number of civilian casualties by coalition forces than the US military had reported. WikiLeaks also published nearly 400,000 field reports about the Iraq War, more than 15,000 unreported deaths of Iraqi civilians, and the systematic murder, torture, and rape by the Iraqi army and authorities that were ignored by US forces. WikiLeaks also published the Guantanamo files, 779 secret reports containing evidence of the US government's torture and abuse of nearly 800 men and boys at Guantanamo. And that abuse, that torture and abuse, violated two treaties the US has ratified, the Geneva Conventions and the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Now, I'm sure that many of you know that under the Supremacy Clause of the Constitution, treaties shall be the supreme law of the land. So when people say, oh, that's just a treaty, international law, it doesn't really apply, when the US ratifies a treaty, it becomes part of domestic US law, and we are bound by it. Perhaps the most notorious release by WikiLeaks was the 2007 collateral murder video. It depicts a U.S. Army Apache helicopter target and fire on unarmed civilians in Baghdad. At least 18 civilians were killed, including 2 Reuters reporters and a man who came to rescue the wounded. 2 children were injured, and then, to add insult to injury and evidence of a third war crime under the Geneva Conventions, a U.S. Army Jeep drove over one of the bodies, cutting it in half. So we have evidence of 3 separate war crimes under the Geneva Conventions. The Obama administration declined to file criminal charges against Assange, even though Obama had prosecuted more whistleblowers than all other prior presidents combined. But the Obama administration was afraid of setting a precedent, a dangerous precedent, and I'll talk a little bit more about that in a minute. Now, the Trump administration exhibited no such forbearance and charged him first for hacking and then a superseding indictment under the Espionage Act, and Julian Assange is facing 175 years in prison. No media outlet or journalist has ever been prosecuted under the Espionage Act for publishing truthful information, which is protected First Amendment activity. Journalists are allowed to publish material that was illegally obtained by a third person if it's a matter of public concern. And the US government has never prosecuted a journalist or a newspaper for publishing classified information, which is an essential tool of journalism. The classic activity that is protected by the First Amendment, freedom of the press, is information gathering, reporting, and disclosure. That fits the classic definition of protected First Amendment activity. And there's no distinction between what WikiLeaks did and what the New York Times, Der Spiegel, Le Monde, El País, and The Guardian did as well. They published articles based on documents that WikiLeaks released. This is the reason that the Obama administration did not prosecute Julian Assange. They considered it and rejected it. They feared establishing, quote, a precedent that could chill investigative reporting about national security matters by treating it as a crime, according to Charlie Savage of the New York Times. And Obama could not distinguish between what WikiLeaks did and what news media organizations like the New York Times do, in Savage's words, soliciting and publishing information that they obtain that the government wants to keep secret, unquote. This is what is known as the New York Times problem. The US government claims that Assange endangered informants in Iraq and Afghanistan who were named in the published documents. But during his 3-week extradition trial, Julian Assange's extradition trial, John Getz, an investigative reporter who worked for Germany's Der Spiegel, testified that Assange took great pains to ensure that the names of US informants were redacted to protect their identities. Moreover, and this is something we don't hear a lot about, WikiLeaks revelations of these war crimes by the US government actually saved lives, because after WikiLeaks published evidence of Iraqi torture centers that the US had established, the Iraqi government refused Obama's request to extend immunity to US soldiers who commit criminal and civil offenses there. And as a result, Obama had to withdraw US troops from Iraq. WikiLeaks also revealed evidence of wrongdoing by other countries besides the United States. They uncovered Russian surveillance. They published exposés of Assad in Syria. And some people say that WikiLeaks' exposure of corruption in Tunisia and torture in Egypt helped catalyze the Arab Spring. 10 years on, the war logs remain the only source of information regarding the many thousands of violent civilian deaths in Iraq between 2004 and 2009, according to Iraq Body Count, which is the premier organization that monitors credibly reported casualties in Iraq since Bush's 2003 invasion. And WikiLeaks cables have contributed to court findings that US drone strikes are criminal offenses and that criminal proceedings should be initiated against senior US officials involved in those strikes. For example, the International Criminal Court has decided to mount a formal investigation into Taliban and Afghan and US leaders that participated in the commission of war crimes and crimes against humanity. Now, ostensibly, to get around allegations that they were prosecuting Assange for conducting journalism, the Trump administration tried to paint him as a hacker, accusing him of conspiring with Manning to break into a government computer to steal government documents in violation of the Computer Fraud and Abuse Act. But as Patrick Eller, a digital forensic expert, testified at Assange's extradition hearing, the attempted cracking of the password hash was not technologically possible in 2010 when the alleged conversation between Assange and Manning occurred. And even if it were feasible, the purpose would not have been to conceal Manning's identity and would not have given Manning any increased access to the government databases. In January, the British judge Vanessa Baraitser, actually I should back up a bit. Julian Assange, and so Baraitser released her decision on whether or not the US government could extradite Julian Assange to the US for trial. So let me back up. Julian Assange is being held in the Belmarsh prison, high security prison, maximum security prison in London, where he's been held in virtual solitary confinement, exposed to COVID, which is running rampant there. And he also has some very serious health problems that stem from his 7 years when he received asylum in the Ecuadorian embassy in London. And I'll give you just a little bit of background. Sweden was investigating him for alleged sexual assault. And later they dropped those charges. The complaining witness, I think there were 2 of them, recanted. But meanwhile, the US government was likely working behind the scenes to get Sweden to extradite him to the United States if he actually went to Sweden. And so what he did was to go into the Ecuadorian embassy in London, where they provided him with asylum for 7 years until the government in Ecuador changed. And then they said, okay, we're going to let the British authorities arrest him, which they did. And he was held on a bail jumping charge. He's been held there for more than a year. While Assange was under that grant of asylum in the embassy, he had some very serious health problems. But during that time, even though he was given asylum by the Ecuadorian government, the British government refused to allow him to go to a hospital to be treated without promising that they wouldn't arrest him. And so these things got worse. And there is a provision in the Convention Against Torture, which, as I said, the US has ratified. It's called non-refoulement. And it means that a country cannot extradite someone to another country, in this case, Britain extraditing him to the US, if there are substantial grounds to believe that he would be in danger of being tortured. And ultimately, we'll see what the judge ruled. Although she didn't mention torture, there was a similar kind of ruling. So let's move to that. In January, Judge Baraitser ruled that actually denied Donald Trump's request for extradition of Assange to the United States. But the ground had nothing to do with the First Amendment. She said that given all the expert testimonies from psychiatrists, prison officials, etc., that Julian Assange would be at a high risk of suicide if he were extradited, because the US prison system could not protect him. So her decision was actually an indictment of the US prison system. But at the same time, the judge spent most of her 132-page decision supporting the Trump administration's case against Assange, which, as I will explain in a moment, amounts to the criminalization of national security journalism. The UK 2003 Extradition Act forbids extradition if the physical or mental condition of the person is such that it would be unjust or oppressive to extradite him. So if Assange is extradited to the United States, the expert testimony at his extradition hearing came out or revealed that he would be incarcerated in a US supermax prison and held in solitary confinement for 23 hours a day, which has been called cruel, inhuman, and degrading, and even torture, because it can lead to suicide, hallucinations, catatonia. And he would be held under special administrative measures, which are onerous conditions resulting in virtual isolation. Baratzer, the judge, in her decision relied heavily on the written testimony of Professor Michael Koppelman, who's an emeritus professor of neuropsychology at King's College in London. And Professor Koppelman diagnosed Assange with recurrent depression and post-traumatic stress disorder, PTSD. She cited Professor Koppelman's assertion, quote, "I am as confident as a psychiatrist can ever be that if extradited to the US, if extradition to the United States were to become imminent, Mr. Assange will find a way of suiciding," unquote. And the judge noted that other experts had corroborated Koppelman's predictions of suicide. So Baratzer's decision is ultimately an indictment of the brutal US prison system that wouldn't be able to protect Assange if he were extradited to the United States. But the judge had no problem with the US government prosecuting Assange for practicing journalism. The indictment against him charges that Assange and WikiLeaks obtained and published classified information that Chelsea Manning had provided to them. And many of the charges allege that Assange had, quote, reason to believe that the information would be used to damage the interests of the US or used to the advantage of a foreign nation, unquote. As I said, the material that Assange and WikiLeaks published contained evidence of war crimes committed by the United States. Now, basically, what the Trump administration was trying to do, and I'll talk about the Biden administration in a minute, and the judge had no problem with, was criminalizing national security journalism. What Assange and WikiLeaks did, it was the very essence of what journalists do. They cultivate sources, they communicate with them confidentially, they protect the confidentiality of those sources, and they publish classified secrets. And if publication of national security secrets violates the Espionage Act, we wouldn't know about US government misconduct in the so-called war on terror. For example, the Washington Post during the Bush administration exposed the CIA black sites where torture was systematically conducted. And that was verified later by the Senate Select Intelligence Committee, which published I believe it was about a 6,700-page report, only 499 pages of which were the executive summary was made public. And if you want a disgusting read that will turn your stomach and about what the US government did during the Bush administration, torturing people, I would recommend that. So if if national security secrets, if the revelation or the publication of national security secrets violated the Espionage Act, we wouldn't know about the CIA black sites. We wouldn't know about the torture and abuse of prisoners in Afghanistan and Iraq that the New Yorker and 60 Minutes too disclosed. And we wouldn't know about the warrantless surveillance program during the Bush administration that the New York Times revealed. Noam Chomsky said at a webinar in January in which I participated that governments always, the US government always invokes national security when it doesn't want the people to know what they're doing in their name. And he said that national security really means the security of the state against its own citizens. So the Trump administration, on the last day, I guess, as Trump was leaving office, filed an appeal of Judge Baraitser's ruling denying extradition to Julian Assange. And if the US loses that appeal, assuming that the Biden administration continues that appeal, and I'll talk about that, if the US loses, then it can appeal to Britain's Supreme Court and ultimately to the European Court of Human Rights. The appellate process will take several months. Ultimately, it's unlikely that Baraitser's ruling will be reversed on appeal because she tailored her decision. She limited it to a very narrow ground, that is Assange's mental health, and accepted most of the US government's allegations. So President Biden had and has a golden opportunity to dismiss the indictment against Julian Assange and protect investigative journalism. But nevertheless, the Biden administration has signaled that for now, it is continuing the Trump administration's effort to extradite Julian Assange to the United States to prosecute him for these alleged offenses, which would garner him 175 years in prison. In February, the U.S. government filed a brief in the appeal, and it has not been made public. I wonder why not. A Justice Department spokesman, Mark Raimondi, said that the U.S. government was not permitted to distribute it, but confirmed that the brief had been filed. And he said, quote, "We are continuing to seek extradition," unquote. In the new brief, the Justice Department was expected to defend how the FBI handles security inmates and to argue that the conditions under which Julian Assange would be held were not a legitimate reason for a close US ally, Britain, to block an otherwise valid extradition request. So what's happening now is that the appeal is proceeding. The US American public and people in other countries around the world are denied any insight into the grounds for the Biden administration's brief in support of the appeal. And there has been a great deal of public pressure by human rights organizations, including my organization, the National Lawyers Guild. I also work with the International Association of Democratic Lawyers and many other groups to pressure the Biden administration to dismiss this appeal because it poses such a threat to national security journalism and criminalizes the revelation of US war crimes. So I'm going to stop there, and I'm sure that people will have questions or comments. So thank you so much.
Thank you so much, Professor Cohn. That's great. And thank you for giving us that update. So if anyone has a question, feel free to unmute yourself or raise your hand and I can call on you. Or if you just would like to put in the chat, you can do so. And I can sort of start off the questioning while we wait for some other questions to get going. And so I was sort of wondering if you could provide any insight on your thoughts of the long-term implications of journalism that has resulted from this. Are we seeing more hesitancy from journalist outlets on reporting national security matters after WikiLeaks and after seeing the government's response. Because I'm very appreciative of the way lawyers like yourself and advocacy groups have rallied around Assange, but we've not seen much from many of the journalist outlets. And so I was wondering if you could comment on that.
You know, I am not aware specifically, Nick, that journalists have been pulling punches, investigative journalists, since during this whole ordeal that Assange is undergoing. But I guarantee that if he is ultimately extradited and put on trial under the Espionage Act and convicted, heaven forbid, that will chill the willingness of national security journalists, investigative journalists, to accurately and fully and publicly reveal evidence from classified sources, confidential sources, and publish those. The implications of this case are vast. And many people, it's not on the radar of many people. We hear hardly anything about it. There's almost nothing about it in the US corporate media. There is a great deal about it in the foreign press, particularly in Australia. Julian Assange is a citizen of Australia, etc. But there's been almost a total blackout. Now, there was a story by Charlie Savage in the New York Times in February when the Biden administration filed the brief, the secret brief, that we haven't seen, in support of the Trump administration's appeal of the judge's denial of extradition. So I think that I can't really point to any journalists who have pulled punches, investigative journalists, yet, but I think that there's no doubt that that will happen if Julian Assange is extradited, tried, and convicted under the Espionage Act.
Thank you. So, yeah, Marshall?
Hi, and thank you so much for coming to talk to us today. It was really informative. I just have a question. Let's say Assange does get convicted of under the Espionage Act. What do you see the chances of a higher court overturning that appeal, overturning that conviction on like First Amendment grounds?
That's a good question. The indictment has been filed in Virginia in one of the most conservative circuits in the country. This is the same circuit where many of the so-called war on terror cases have been brought. And I don't think that that was accidental on the part of the Trump administration. So if Julian Assange is convicted, is ultimately extradited and convicted, then there would be an appeal to ultimately probably to the Supreme Court. And I am not confident, given the current makeup of the Supreme Court, that it would reverse a conviction. Now, I could be wrong about that. I hope I am. I hope he doesn't even get extradited. And if he does, he's not convicted. But if that happens, I am not confident that there would be a reversal of his conviction on appeal.
If anyone has any questions, you can just raise your hand, utilize the raise hand function. Well, I had a question, about sort of legal strategy on this front, and this doesn't necessarily have to pertain just to the Assange case, but I think it's informative as lawyers concerned about international human rights and civil liberties. What's your outlook on using these international treaties as a tool for litigation, not only on large scale cases, but even smaller cases?
I appreciate that question, Nick. And I do a lot of work in the area of international human rights, and particularly with the treaties. As I've said, when the US ratifies a treaty, it becomes part of US law under the Supremacy Clause. The US has ratified the Convention Against Torture, the International Convention on the Elimination of All Forms of Racial Discrimination, and the International Covenant on Civil and Political Rights. But the U.S. refuses to ratify, although it's signed but not ratified, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention on the Rights of the Child, the Convention protecting the rights of persons with disabilities, the International Covenant on Economic, Social, and Cultural Rights. Let me just quickly lay out the difference between signing a treaty and ratifying a treaty. When a country, in this case, the US president, signs a treaty, that indicates an intent to ratify. And under the Vienna Convention on the Law of Treaties, once a country signs a treaty, it cannot take action inconsistent with the object and purpose of the treaty. Now, the US Constitution provides that in order to ratify a treaty, the president must get advice and consent from 2/3 of the Senate. And so, for example, the International Criminal Court statute, the Rome Statute for the International Criminal Court, which was 50 years in the making, the US participated in developing that statute. As Clinton was leaving office, he put the US signature on that treaty, but he recommended to George W. Bush that he not send that treaty to the Senate for advice and consent to ratification. So not only did Bush refuse to send the treaty, the Rome Statute, to the Senate for advice and consent to ratification, in an unprecedented move, George W. Bush unsigned the Rome Statute, took the US signature off the Rome Statute. Well, let's back up and get more directly to your question. The US, when it does ratify a treaty, and I've told you the US has ratified those 3 human rights treaties, it attaches what are called RUDs, reservations, understandings, and declarations, purporting to limit US obligations under the treaty. Keep in mind that the Vienna Convention on the Law of Treaties, which the US has agreed to be bound by under customary international law, which means the custom and practice of states, which is as binding as treaties, but it's a different source of international law. The US has agreed to be bound by the Vienna Convention on the Law of Treaties. And that convention, the Vienna Convention, says that a reservation which is inconsistent with the object and purpose of the treaty is void. The US has attached reservations, understandings, and declarations to its ratification of those 3 treaties I mentioned: the Torture Convention, the Race Convention, and the International Covenant on Civil and Political Rights. And one of the reservations it has attached says that the treaty, these are all considered treaties, even though they're called conventions and covenants, that it says that the obligations in those treaties are non-self-executing. That means that they require federal legislation to be able to use, for plaintiffs to be able to use their provisions affirmatively in court cases. The US has executed the Convention Against Torture with the US Torture Statute, a federal statute, but it only punishes torture committed abroad. It's never been used. It's never been the basis for a criminal prosecution. It has also been executed, the Torture Convention, through the Torture Victim Protection Act, which is a civil treaty, a civil law. So when plaintiffs bring these treaty arguments to the courts are not too familiar with them. In fact, there's a really interesting anecdote. I was at a law professors conference years ago. We were at Georgetown Law Center. There was a program where Justice Breyer was on the stage with the dean of the Georgetown Law School, and he was talking about international and foreign law, and he actually conflated the two. Justice Breyer, Associate Justice of the Supreme Court, didn't understand the difference between international law and foreign law. International law, as I've said, once there is a ratified treaty by the United States, it becomes part of US law. Foreign law means the law of France, the law of Saudi Arabia, the law of Iran, the law of Britain. That's foreign law. And when I asked him, when I confronted him about that, and in a very nice way, of course, he still didn't get it. And I said, why doesn't the Supreme Court use ratified treaties in their decisions? And he really did not answer that question satisfactorily. Now, there has been some use of the treaties. Justice Ginsburg, may she rest in peace, did cite the Race Convention when she wrote opinions about affirmative action. Justice Kennedy used the Convention on the Rights of the Child when he talked about the unconstitutionality of using the death penalty against juveniles. But it's really, really important that lawyers like yourselves, prospective lawyers, future lawyers, understand these treaties so that you can use them in your litigation, not as the only legal argument. The Torture Convention is used frequently in immigration cases, that non-refoulement provision, to refuse to send somebody back to a country where they would be in danger of being tortured when people apply for asylum, for example, political asylum. But it is incumbent upon us as lawyers and future lawyers to bring these arguments to educate other lawyers, and indeed to educate judges at all stages of the proceedings, including all the way to the Supreme Court.
Absolutely. Yeah, thank you. We have time for a few more questions if anyone has one. Yeah, Hannah.
Yeah, I guess this maybe gets a little bit away from your talk, but I was wondering if you would recommend that in law school, I mean, a lot needs to change with the law school curriculum, but if one of the things that we changed is like having a required international law course or required international human rights course, or what that would look like, or if you think that's something that we should have, because I think in general, as law students, we don't necessarily learn much about that area of law unless we take specific classes on it. And I think like the American public in general is fairly, doesn't know that much about international human rights law and, ways to use that in order to affect change in the United States.
That's a good question. And I can conceive of a course called International Human Rights as part of US law, for example, not just in general human rights law or international law, but actually teaching students, law students, how these US obligations under international law are part of US law so that they can use those in litigation. And I think it would be great to have a required course in that area. I don't know that would happen. Law schools tend to reduce the number of required courses and allow students to take more electives. But I would also like to see it tested on the bar exam. And if it was tested on the bar exam, then you can bet that many law schools would add that course as a required course. And I should also say that even though the US purports to limit the use of treaties in domestic cases, we still have obligations on the international plane under ratified treaties, and ratified treaties and even treaties that the US has signed are used commonly, routinely, as interpretive guides to, for example, US constitutional law and other forms of US law. Although many lawyers and judges don't know that, and that's why it's so important to offer a course, as Hannah suggests.
Absolutely. Any other questions? Okay.
People probably agree with everything I said, right? Nothing controversial.
Right. There we go. Well, I can sort of ask this question to sort of close on, and it's sort of this overarching theme of what can we as law students do to help out with the Assange defense efforts if we're interested, because part of that strategy I see is, number one, raising awareness, but also part of that includes informing these prospective lawyers about this issue and sort of the changes that could result from implications of this current case. And so I was wondering if you could give us any insight on how we can help out with your current efforts and the defense team's current efforts.
Well, I would recommend that people visit the website Assange Defense, which I work with. I'm on the board, and I've done a number of webinars and programs with them. And also, one thing the US government, and I'm talking about the White House and Congress legislators, respond to is pressure from their constituents. And I strongly urge people to send letters, emails, telephone calls to the White House and to your elected senators and congresspersons, stressing, demanding that the indictment against Julian Assange be dismissed. And they do respond to that. They add up how many communications they get on various issues. And right now, the ball is in the executive court, the Biden administration. So I think pressure on the White House is essential. But also, if there were a groundswell in Congress, that also could impact how the Biden administration continues or doesn't continue this appeal. So I recommend visiting Assange Defense, the website, and also pressuring the White House and your congressional representatives to drop the case against Julian Assange to protect investigative and national security journalism.
Great. Well, thank you so much, Professor Cohen, for coming and speaking with us today. And we're so happy we could have you. We're none of us are very happy about Zoom School of Law, but one of the benefits is we can have great speakers from across the country to come and speak with us and update us on important matters of the day. And Hannah has generously provided both Professor Cohen's personal website, where you can follow her updates and her essays and blog posts, as well as the Assange Defense website. And so thank you again, Professor Cohen, for speaking with us and all the work that you're doing along with everyone else at Assange Defense. I will stay updated on what is going on because this is a crucial matter. And I certainly, personally, I hope that Julian can be able to find freedom sometime soon.
Thank you so much, Nick, and thank you, Hannah, and everyone who organized this. And good luck, everyone, on your exams.